I'm Jim Barton. I'm a director in HMPPS. I look after capacity implementation, which includes electronic monitoring.
Excellent. We're delighted to have you with us. This is our last evidence session on our inquiry into electronic monitoring, or tagging as some people will call it, and we're very grateful to see you. Before we begin, however, discussing electronic monitoring, we were very pleased to receive just 24 or 48 hours ago the government's response to our very detailed report on prisons, and we're obviously delighted that in large part the government has accepted the recommendations within it, although, as we will explain in more detail in our response to that, we do believe that in some areas there is a degree of complacency in that response, and we will be commenting on that. However, there are two areas of particular and immediate concern that have arisen. The first is in relation to education provision within our prisons, and I know, Lord Timpson, that you've been particularly keen that prisons act very much as an opportunity for rehabilitation, for reducing reoffending, and a key part of that is the provision of educational opportunities to prisoners. At the same time, The Guardian has now reported that there have been cuts to the prison's education budget, in some cases of nearly 50%. That's clearly deeply worrying at a time when we were recommending increased educational provision, and in your response you were arguing of the importance of educational provision. I just wonder if you can explain what is going on, and more importantly, what are the plans to resolve this problem?
Well, as I've said to the committee in the past, and also what is clear to those who've been into prisons recently, is we're dealing with prisons in crisis, and it's our job to sort it out. Education is one of those parts. I completely agree with your observation that education is absolutely key. It's one of the pillars of rehabilitation. Being able to read and write is key, but also it's not just about education, it's about giving people skills for when they're released, whether it's in construction, whether it's in recycling, whatever it is. We haven't reduced the education budget, it's just we're getting less for our money because costs have gone up. But obviously got a new spending round. Our 3-year spending review is about to start, and the allocation process is imminent. We're having those discussions. So that's my job, to work hard on that. I'm also interested in, it's not just about the budgets, but how we use education. I've seen too many classrooms in prisons that have all the kit in there, but no prisoners are in there. Some of that is down to regime, some of it is down to other issues, but it is also about using our resources far more effectively. Because in some prisons, I just think we just need to push that a lot harder. So I think it's a combination of looking forward on the expenditure on education and fighting our corner hard. I also think it's about thinking about what are the other options on rehabilitation, not just education, but giving them skills so when they're out they can get a job, but also utilising the opportunity in the facilities that we have in prisons far more effectively. I know in some prisons where they are, where for security reasons they are locking people down. I know in some of our young offenders institutions there's problems around gang affiliations and be able to get classrooms operating safely with a number of people in. So I do understand the challenges, but I also agree that education is absolutely vital.
I'm grateful for that answer, which sounds a bit more optimistic than the other evidence that we've received would suggest. Could you then, if the education budget hasn't been cut, but the problem is in relation to increased costs, tell me whether or not The Guardian is correct with a statement that says the budget for classroom courses at HMP Leicester will be cut by 46.5%. Is that correct?
I don't know the details, so if it's okay, I can write to you with the exact details on that specific prison. But my understanding is that generally on education, the way the 3-year contracts operated is that the the last year was and the costs have increased, that's where it's been hit. So if it's okay, Chair, I will write to you with exact details.
I'm grateful for that, and it would be helpful that that's done as quickly as possible, because, for example, another thing the Guardian says is while a women's prison is cutting its provision in education by 26%. Now, 26% in 1 year does not seem, on the face of it at least, to just be an explanation for increased costs. I mean, costs have not gone up by 26% in 1 year period.
So again, I'll write to you on that one, because some of it is the complexity around how these contracts work, and how. So I don't want to give you. I don't know the exact details on that, but I will write to
and just so we're absolutely clear, your department and the MOJ is presumably lobbying extremely hard to the Chancellor in relation to the budget to ensure that this doesn't continue.
Well, we already have our allocation, but we haven't divvied up our allocation. So that's for the MOJ and myself to I'm sorry that this is eating into time to discuss electronic monitoring, but we think it's very important. Another issue that has emerged within the last 24 hours is the fact that in our report we talked about the vital importance of increasing recruitment and retention of staff. We also talked about measures to try and reduce the level of sickness, because we are deeply concerned about staffing within our prisons. The response suggests that the government shares those concerns. At the same time, we now learn that a very large number of prison officers who have come from overseas to work in our prisons will be affected by the government's changes to the skilled worker visa arrangements, whereby the limit, the salary is now to be £41,000 thereabouts, and the vast majority of prison staff will not be reaching that salary, and so will no longer be able to obtain a visa and come. And given a very high percentage of prison staff are coming from overseas, that is clearly a very serious and immediate concern. Again, your reaction to that? As you said in the report, retention is absolutely key, as is sickness. Having improved retention and less sickness for any organisation, but especially one where we're so reliant on our. I mean, I think working in a prison is the most amazing job, and if I hadn't have gone down my path as a commercial life, I just think it was one of the most rewarding, rewarding jobs. We have done a really good job on recruitment. The quality of people we're recruiting, I think, is strong, but we need to do a lot more work on it. But on the other hand, net migration must come down, and as a government, we're committed to tackling the skill shortages in the labour market and the failures we have in the labour market. Anybody with a skilled worker visa is exempt, and we're providing support to those who are affected.
Obviously appreciate the answer you gave, but if the reports, the newspaper reports, are correct, there is a very immediate impact on staffing numbers in prisons that cannot be resolved by measures over time to improve retention and so on, and recruitment of people from within the UK. So it would be very helpful if you could write to us as a matter of urgency with what your analysis of that impact would be, so that we all have an understanding of how significant or otherwise the problem is. So if you'd be willing to do that, together with any further comments, that would be very helpful.
Of course, and if it would be helpful, I could also update you as part of that on what we're doing on training, because it's not just about retention, it's about how we train our new staff. And the work that I did before I came into government on prison officer training is starting to kick in now, and that may be helpful to put into context.
Thank you very much. In that case, with those two questions on our prisons report, of which we'll have further discussions at a later stage, let us now return to our inquiry into electronic monitoring. And just so anyone watching is aware, we've taken evidence from a number of other witnesses We've also had written evidence from a number of individuals and organisations on this issue. This is our final evidence gathering session on this issue, which will be kicked off today by Lord Bark.
Thank you very much, Lord Chairman. Good morning, Minister. Good morning, Mr. Barton. The general question I'm asking is, what does the Ministry of Justice see as the purpose of electronic monitoring? I suppose another way of putting that question is saying, can probation manage offenders just as effectively without resorting to electronic monitoring? And you'll know that the reason why those questions are asked is because of the unsatisfactory nature, so far at least, on data showing whether electronic monitoring really has much of an effect in terms of those on whom it is given. I refer to the 2022, and I'm very conscious that's 3 years old now, NAO report, which found the evidence base in general weak, and that the MOJ agreed, I think, with the NAO at that time that its transformation policy wasn't as strong as it should have been. So really I'm asking for an update, but I think the really important question is there a real purpose that behind electronic monitoring, or is it really just being used as a necessity to keep prison numbers down?
I think electronic monitoring has an absolutely key central role in the justice sector. Its role is as punishment. It is for public protection and to support victims. It has a very important and increasingly important role in victims, but also in rehabilitation. If you take alcohol tags, for example, they have a 97% compliance rate. And I've actually tried an alcohol tag and was forced to go to the pub after work on a Tuesday, and they did the readings the next day, and the technology works. So I think it's got multifaceted purpose, but also the technology is very strong. And so because we know that the technology works, then you look at what the evidence is. And there are two bits of evidence that I wouldn't mind just sharing. One is curfew tags on our evidence leads to a 20% reduction in reoffending for those on community sentences. And also we did an acquisitive crime GPS pilot, which also reduced reoffending by 20%. So I think that's very strong evidence that it works. And the way, I'm sure we'll be talking about this later on, about the issues we had when we first came into government around the delivery of the service. When you look at, compared to other countries, we are the most advanced in Europe on tagging. And I just think the technology is going to get more interesting. Maybe we can come into that as part of this discussion. But I think it's just absolutely key to what we are doing. Yes, it's an alternative to custody, but it is a punishment, and the data that it gives us is really powerful.
Thank you. Mr. Barton, anything you want to add to what the Minister said on that?
At this stage, thank you.
Lord Tope.
Yes, thank you, Minister. Mr. Butler, if you wish to join in. 2 weeks ago, one of our witnesses here, in fact, he was the, I want to name him directly, director of the Centre for Crime and Justice Studies, referred to this, the forthcoming substantial change in the justice system that's coming, and on tagging in particular, EM in particular. When we asked him if a strategy needed a fundamental rethink, he said, and I'm going to quote him, "Yes, it does at this point, precisely because the government are saying they really want to go big on EM." Is there going to be a new strategy?
There is not going to be a new strategy, but we need to expand the way electronic monitoring works and how we deal with offenders in the community. Essentially, we need to improve the accuracy of the delivery of the service, and also to see how far we can spread it to help us manage offenders more effectively in the community. So, for example, we're doing a trial starting next month in 6 prisons where we'll be what we call tagging at source. So before people leave prison, we'll be putting the tag on their ankle. And obviously we'll evaluate it, the cost and the impact of that. And beyond that, I think if we can get that one boxed off, the next stage is exploring tagging at court, which is more complex. But so we don't need a new strategy. We need to keep challenging the system and improving the delivery of service. But we also need to look at ways we can improve accuracy and improve the way we use the data.
Would it be right to call it a fresh rethink?
No, I don't think so. I just think...
That was not my comment, it was the comment that was made.
No, I wouldn't.
I was quoting.
From having been in business for a long time and inherited businesses that had problems, I wouldn't say the scale of the problems with the complexity of the electronic monitoring. These things take time to sort, but you need to get the basics sorted first, and that was my area of focus. Now I'm comfortable that the basics are getting sorted. Now we can move to the next stage of looking what else can we do with the technology we have. The technology is really good, but what we need to do is to make sure we grow it and we understand how we can improve accuracy. Because what I want to do is to reduce reoffending, and I think EM has a really powerful role in that. But I don't think we need a new strategy, we just need to keep building on what we've got.
Thank you.
Lord Filkin.
Thank you, Chairman, and welcome, Minister. Again, it's a question essentially about the future direction of your policy for electronic monitoring. The plan is to double its use over the next few years, which is a quite remarkable increase. And the question is, are probation ready for this? Because clearly electronic monitoring has a critical requirement of input from probation staff, and yet they're already under-provided on this dimension. And secondly, what do you think about the private sector suppliers? They will tell you they're ready, but are you content with just 2 suppliers?
Well, as we expand electronic monitoring, we need more engagement. We need more kit, and we need more work with our providers. We also need more probation staff. So that's why the last year we recruited 1,050 extra probation staff. Next year it'll be 1,300. And it's obviously a case of recruiting them and training them up to do the job. And that's where the 700 million of extra funding that we've got over the next 3 years is absolutely vital, because it's more tagging, it's more staff, it's more accommodation, but more staff is absolutely vital. And I am confident in our suppliers' ability to deliver this, because I have ongoing conversations. I've had 5 board-level meetings with Serco. I've been to their centre in Warrington, where they do all the day-to-day. It's their sort of call centre, which has got about, I can't remember how many staff it has there. But also, we've been just having ongoing conversations. So I get a weekly update. I have my electronic monitoring dashboard every week of looking at current performance, and I also get regular updates from colleagues on the future trajectory of increased numbers of tags, for example, we need to buy. So, for example, last week I was having a conversation around what is the minimum stock levels we're going to have of spare kit as we ramp up. So I am confident that we have a really robust plan. We have very good conversations. It's about 200 staff in Warrington, thanks, Jim. But maybe I could just bring Jim in now, because Jim and his colleagues have the much more detailed conversations than I do.
Yeah, so just building on the Minister's evidence, so we're working already now with both suppliers in order to maximise the time that we have available to be ready for the expansion of EM, which is due to come into effect, obviously subject to the parliamentary process around the sentencing bill. Obviously, a kind of an ambition to double the EM caseload sounds on the face of it like a very bold position to adopt, but we have essentially already delivered a doubling of the EM caseload over the last 5 years. So if you roll the clock back to prior to COVID, the EM caseload was about 10,000. As of the last stats that we published in June, it's now about 24,000. So we have got a track record of delivering significant expansions and innovations, as the Minister referenced, in the way that we use EM. Our job of work now is to get our head down with the suppliers and with Probation to ensure that we are ready for that further expansion as it starts to build next year. Very much agree with the premise of the question that Probation is key to this. As the Minister said, significant investment in Probation, up to 45% higher budget by the end of this spending review period. But we also need to really focus, as we are, and as the Minister is rightly applying pressure to us to do, on Probation workload. So how do we streamline process? How do we make best use of digital tools to ensure that Probation staff are spending more of their time, as they would want to, face-to-face with offenders, looking to tackle the factors that are driving reoffending? And that's where EM is so powerful, because it provides Probation staff with data, with information for them to have richer, more impactful conversations with the people on Probation that they're working with.
Can I just press you again on the private sector, and in doing so declare a historic interest? 20 years ago, I was an advisor to Serco, so I've got some understanding of the other side of the fence. Let me put it to you that it is inherently, you have a duopoly effectively with just two suppliers at a time when you are doubling your demand. It would seem to most people, it cried out for increasing the number of suppliers so you could increase your competition and you could increase your options if things started to go wrong with one or both suppliers, as they have done in the past. So why are you not planning to do that? Is it because the contract doesn't allow you to bring in other suppliers, or because you don't think it's necessary? To you, Minister, if I could on that.
Thank you. This is a contract that we inherited, and obviously when we came into government 14 months ago, the thing was very problematic, and it's now in a much better place. The contract that we inherited is scalable. I wasn't around when those negotiations were going on what contract was that they wanted to have, but from my experience, it's about how you deal with what's in front of you, and it's about communication and having robust conversations, as I have had numerous times with Serco and with other partners as well, because we are paying for a service and we need to make sure we get really good value for money and they deliver what they need to do, but also we need to deliver our side of the bargain too, because this is very much a partnership, and it works well when they come up with the standards that they've said, and we do too. So maybe I can hand over to Jim because this was before.
Just before you do, the implication of what you've said, Minister, is that you're contractually locked in to those two suppliers. Could I ask then, for how long are you contractually locked in to those two suppliers?
I'm happy to come in at that point, Lord Filkin, if that's okay. So a few points. So the current contracts run until 2030. The contracts are not monopoly contracts. So if we wanted to, we would be able to run parallel competitions for alternative EM provision. We don't.
Can I ask why you don't think that's necessary?
Sure. We don't want to do that, and we don't think that's necessary for a number of reasons. So the first is, not necessarily in this rank order, but the first is around economies of scale. So we took a conscious decision when we designed the procurement that led to these contracts that we thought the best value for money for the public purse was having a single provider on the field and monitoring service side, Serco, and a single provider of the equipment, Allied Universal. That's consistent with most jurisdictions. Most jurisdictions don't have two organisations on the same geographic patch providing the same service. There were choices that we worked through about exactly how we packaged up the different aspects of the EM service. I think you received evidence from David Byrne from Allied Universal, who referred to Scotland, where all of it is with a single provider. We chose not to take that approach because we thought that really would limit the number of market providers who would have been able to bid into that process and therefore would not have provided quality and value for money through the competitive process. The second reason why we're not proposing to run a parallel competition process is that it takes too long, to be frank. So we're anticipating the increase in EM to continue. EM has grown by something like 3,000 in the period that the Minister has been with us. It will continue to grow through the course of this year and into next. A compliant procurement process would take us something like 2 years as a minimum to be run. That distracts a huge amount of effort from what should be our priority, as the Minister has described, which is working with Serco and Allied to ensure these contracts are delivering and that they're ready to deliver on the expansion that we require.
Okay, that's very frank. You're clearly got strong reasons for why you can't change, but there will be an open question about how you plan for 2030, won't it? For which there's not time now. Thank you, Chair.
Thank you very much. Just so we're absolutely clear, the contract, as we understood it with Serco and with Allied Universal, is basically a 6-year contract from 2024 to 2030, but there is also then an additional 2-year option for extending that. During that period of time, you have said you could be in a position to run a parallel contract or contracts, which presumably could be for additional tags that might come as a result of, for instance, the Sentencing Act and so on. Could you just explain to us, just so we're clear, what exactly that parallel contract could be? We understand your argument why you don't want to do it, but just so we know what it is you're rejecting.
Thank you, Lord Chairman. So just to be really clear, we have absolutely no plan whatsoever to run a parallel contract for the provision of core EM services, either the fitment of the tags or the physical devices themselves. There are, of course, lots of hypotheticals I could produce in response to that challenge. So there is a world in which we could decide we wanted contracts that ran wholly in parallel with Serco and Allied and mirrored their current provision. I don't see any value in that for the reasons that I articulated to Lord Filkin, because it just creates complexity and a huge amount of wasted public money, both in terms of the procurement activity and then the inefficiency of those two providers operating together. Our contracts work. There have been performance challenges. I'm sure we'll have the opportunity to talk about those in more detail. Performance has improved immeasurably since the position that the Minister inherited just over a year ago. We need to keep working with Serco and Allied.
Sorry, I'm enormously grateful for what you're saying, but it was in a sense you're slightly repeating what you said earlier. My question is, just so we can understand what it is you have chosen not to do, I'm anxious to be clear what it is within the contract you could do when you talk about a parallel. We may come to a conclusion that your analysis of what you choose to do we don't agree with. So we need to understand what the other options are. So let me suggest one to you, that somebody comes forward with a new form of tag which you find would be particularly helpful to become part of the range of tags that we have. It would be perfectly possible for you to have a different supplier and a different monitor of that tag within the current contract arrangements, should you so choose. I'm not suggesting you would, I'm merely asking if it's possible.
As I understand it, in that scenario there is of course an alternative proposition, which is we secure access to that technology via Allied Universal. So some of the tags that they provide to us at the moment are not manufactured by them themselves. So my starting point, I think, would be to build on our existing contractual relationships in that circumstance and look to access that technology via Allied Universal, who are, as David gave evidence, a global provider.
So, Mr. Barton, you're continuing to tell me what you've chosen to do. I'm merely asking whether you have the option to do it differently, should you have chosen to do it differently. I think the answer is yes.
Apologies, Lord Chairman, I think I said yes, but perhaps in civil service terms at the start of that answer.
I think
I'm just trying to
very clearly where you're coming from, Mr. Barton. We will move on. Baroness Cash.
Well, Minister, I believe this is a question for yourself, because you've referenced already the innovations that are coming down the track. So I'd love to go back to that and hear a bit more about what we can expect in terms of, we hear written about under skin tagging, AI monitoring, at home monitoring. So we'd just be very interested to have some insight into what's coming.
Okay. So maybe I'll just go through a list of some of the options that we are looking at and give you an update on our thinking. I think the first thing to say is everyone gets very excited about new things. I get very excited about just doing the day-to-day business really well and not getting diverted too much around the new things. But we mustn't forget what our job is to do, which is to tag effectively and accurately. So we're exploring new hardware. We had a Dragon's Den event before recess, which is really good actually. So we've had two of these. It was the second one, but it was the first time we sort of sat in a room where people have given us pitches of ideas in the justice sector, but a lot of them were around EM or the principles around data and tracking. And you know, what is clear is what we do in in England and Wales here is we are world leading in what we're doing in the volume of it. But there are some really interesting things coming out. The future is not just about hardware, it's about the software and the data and how we use it. But I also think we need to be careful that we don't fall into the data trap of just collecting vast amounts of data and not really knowing what we're going to do with it. So I do think we need to be very thoughtful about our approach. So one of the things that we're interested in that's in the sentencing bill is around restriction zones and using electronic monitoring for restriction zones. So victims get far more support because the perpetrators are restricted to a zone rather than the victim. So that gives you one example of something we are going to do. Also the role of AI. I mean, everyone's getting excited about, everyone thinks it can solve all of their problems, but I do think the way we can use AI with the amount of data that we're already collecting is important. I also think the way that we can use GPS tagging and knowing where offenders are is important, and maybe we can come on to that later. We've also doing a trial on what we call e-supervision, which is a similar technique, which is to allow the probation officer to check in with an offender without them having to come into the office. So we can do regular, frequent checks. Live access for probation to where someone is, we're trialling that from spring next year. So we'll be able to check in. So for example, offender comes to see a probation officer and they say, well, why weren't you at your appointment last week? And they said I was at the doctor's. They'll be able to go in and say, well, you weren't at the doctor's, you were at Blackpool for the day. So that will give us more reassurance, because one of the things that I am really determined to do is if offenders don't comply, I can have sanctions on them and I can recall them back to prison, because it is a punishment and we need to use the data effectively. We're not thinking of trackers under the skin at all. There are lots of medical, ethical and legal implications on that, and I don't think the tech's there. But for me, what I'm really interested in is that we are thoughtful in our approach. We trial things in a small way, but what we need to do is to make sure that it reduces reoffending. That's why I'm here, to reduce reoffending, and I think EM is a really important route to do that. So I think it's really exciting, but we need to make sure that we don't just fall in love with anything that's new and forget about the day-to-day part of the business.
Just one quick follow-up. It's about best practice elsewhere, what we've learned and what you've learned from other jurisdictions, and if there's anything of note for the committee on that.
Well, I'll just give you one example from one of the pitches we had at the Dragon's Den, and maybe then I'll hand over to Jim for some of the other examples that Jim will know more details on. There was a company from New Zealand that came to see us. It came all the way from New Zealand, and they're doing a trial in Queensland at the moment with the way probation works with technology and how offenders go to job centres where there's a terminal there and they can link in to say where they are and how they're getting on. But I have this vision in my head of, number of you may have Apple Watches, or people who have Apple Watches. They know where you are. The technology is already there to basically work out whether you're taking drugs or not based on your heart rate. But we can send you messages. We can send. It could be your GP. It could be your therapist. It could be part of your AA, NA circle. So, I do think there are lots of different ways we can embrace technology. But certainly for EM, I think it's really interesting.
Very interesting, thank you.
Do you mind if I hand over to
please.
Just a few very quick additions, if I may. So alcohol monitoring, I think, is definitely something where we've learned from the States, where that has been in use for considerably longer than here, but we are now, I think I'm right in saying, by far and away the biggest user of alcohol monitoring as a technique, as a device across Europe. We are heavily plugged into the international networks around this. So through the Confederation of European Probation, there's an EM working group that we're a member of. Those conversations are really about sharing best practice around different models of EM. I think one of the themes that I think has come up in evidence to this committee is around how well integrated EM is as a service with probation. I think it's fair to say that's something that we've been working on hard over the course of the last couple of years. The Acquisitive Crime Pathfinder that I think the Minister referenced is a good example of that, where we're already able to provide, albeit not in a live way, but overnight, GPS data for probation practitioners where they have robbers or burglars on their caseload. So good example of innovation, but we can definitely continue to learn. Proximity devices is something we don't use in this jurisdiction at any scale. So that's where you have two devices, one on the perpetrator's leg, one with usually the victim of domestic abuse. That's used in Spain and a few other places around Europe. We're interested in exploring whether that has a use case for us here in England and Wales.
And there was a trial on that in Northumberland. There was a small trial still going on in Northumberland, which has been going for a number of years on proximity tags.
Very interesting, thank you.
So could I just mention one other thing?
Yeah.
I've always been really interested in the Texas justice system. And one of the inspirations for the progression model and a lot of things in the sentencing bill is what's come from Texas. And there they have a really robust electronic monitoring. Electronic monitoring is a really important part of their offender journey.
Can we just take this a little further? And I accept entirely what you said, Minister, about the importance of doing the day-to-day work really well. And what you said, Mr. Barton, about making the very best use of digital tools. But you asked yourself the question, Lord Timpson, earlier, when you said, what else can we do with what we already have? And I'd just like to explore that a little bit, because I'd be interested to know what consideration has been given to the use of the data that we collect from electronic monitoring together with other ways in which we collect data, for instance, the automatic number plate recognition, live facial recognition, and so on. And it has been suggested to us that while you've talked about the improving the link with the probation service with the data collected, there is also the issue of improving the relationship with the police service so that they could potentially use this collection of data from a wide range of sources, if they could find a way of packaging it together, in terms of crime detection, for example. I just wonder what thinking has been given in that area.
So the acquisitive crime pilots that Jim mentioned, we've got a trial in 19 police force areas where every 24 hours they can download the data of where the GPS tagged offender has been and see if that matches to where crimes have been committed. And that's where we got the evidence that it reduces reoffending by 20%. So we know that works. And I think it's prevented 16,000 arrests already. So that gives you one example of where it can go. Obviously, if you link that in with number plate recognition, facial recognition, I haven't had those conversations with colleagues, but maybe I'll ask Jim in a second to come in on that. But where we're doing the trial, we don't have any powers yet to give real-time access to the police on where an offender is, except if it's for specific purposes. So there are certain offenders that are tracked for intelligence reasons, which not to be discussed today, where we do have that power, but generally that power is not there. But I think the question is, if you pulled all that data together, we tracked everybody, we knew where they were, we knew where crimes were, we had very high-powered computer systems to do that, then we would be able to match offenders' crimes to where they are, to improve the evidence to support police. So I think the trials we're doing are really interesting and helpful, and hopefully they will expand. But maybe if I hand over to Jim, who can enlighten us on the rest.
Yeah, so just to start by emphasising the point the Minister made, we don't have any lawful basis upon which to share the kind of bulk GPS data with the police. I understand that would require primary legislative change in order to give effect to that. Where we can share it is where there is a specific investigation underway where that evidence is relevant. Just to expand on the description of acquisitive crime a little bit, so the way this operates is everybody who is released into one of those 19 police force areas, having served time in prison for robbery, burglary and a few other offences, by default gets a GPS tag on their leg. We then monitor those individuals. Every night the police forces, those 19 police forces, send us a bulk upload of geo-tagged crime offences essentially. So domestic burglaries, robberies, car thefts. We map that data onto the GPS data that we hold and then send back information to the police to rule people in or out as suspects of crime. Ruling people out of being suspects of crime is almost as powerful because it avoids wasted police efforts and it actually avoids some of our people on our caseload being kind of pulled in as just the usual suspect in that case when we know as a fact they were not guilty. That data has been used by the police then to further certain intelligence investigations. So taking car theft as an example, we have examples where an individual wearing a tag has been involved in stealing a car with the tag on their leg, despite knowing that we're monitoring the fact that they have a tag on their leg. The trail of that car has then been followed through a combination of the GPS data and ANPR, and that has then been used to break organised crime groups linked to car theft on an industrial scale. So we do it, but on a very targeted, specific individual case. I'm sure, I think I can say with confidence, police colleagues would prefer that they had greater access to that data, but we don't have the means to do it. We are planning, as the Minister referenced earlier, to make that GPS data available in essentially real time for probation staff starting in spring of next year. We're able to do that because they're part of the same organisation.
And just so I'm clear, and I'm sure you'll be well aware that the scenario I have described as a possibility of linking all these different sources of data would have all sorts of other implications in terms of civil liberties and so on, and they would obviously all have to be rightly addressed. But just so we're clear, the real-time information trial of passing information to the probation service, currently, with the limited exceptions you've given, the passing of real-time information to the police, I mean, is currently incredibly clunky with a sort of email sent some days later in many cases. I mean, in theory, it could be improved should it be thought a good idea, but it would, in your view, require primary legislation to enable that to happen.
So to share mass bulk data by default without a specific investigatory reason would require legislative change. I 100% agree with the point you just made, Lord Chairman, that we should be doing everything that we can to improve the way the system operates now. So if a police constable in a force office somewhere wants access to information to help them advance an investigation, we should be doing everything that we can with Serco to get that information in their hands as quickly as possible.
Lord Bark. It's a very simple question. The sentencing bill that's in the Commons coming to us here, could that be a vehicle for any primary changes in legislation that were necessary, or has it been thought through and it's not a suitable bill for such a change? I just throw it out in case it could even be something that the Lords do, I mean, or consider.
I haven't had that conversation with colleagues.
But it could be looked at and written to us about.
Of course.
Would be.
Yeah.
Thank you. Baroness Hughes.
Thank you, Chair. I'm looking particularly at the use of electronic monitoring by the courts, and I think you'll obviously know that the use of electronic monitoring as a result of court sentences has actually halved between 2017 and 25, while the increase in court bail and post-release has more than doubled. How do you account for that shift, significant shift, particularly in the fall in the use of electronic monitoring as a court sentence, particularly given we're interested in as an alternative to prison. And do you think it reflects a lack of confidence amongst magistrates and judges about the rigour, the effectiveness of electronic monitoring? You said a number of times, Minister, you see electronic monitoring as a punishment. Do you think the judiciary, the magistracy, and perhaps the public don't see it as a punishment, and does the government need to do more work on that space?
Justice system we inherited has been in crisis for a long time. If you look what happened with transforming rehabilitation, it broke probation and the challenges that then caused on the courts and the backlogs we got in the courts. Electronic monitoring is widely available in the courts, and when I mentioned before about the trial we want to do in due course on tagging at source at the courts, I think is important. I believe the technology we have is world class. It works. Yes, we inherited a contract that was underperforming. It is now performing much better to the extent that I would describe it's not on my worry list. But I understand there is, I get questions from friends outside of work to say what's going on with tagging. So I do think the stories in the media have raised awareness of the problems that we inherited. What I hope is that we deliver on improving the levels of service, and that will be reflected in the views of magistrates and judges too. But for bail, as you say, it's gone up from 2,800 in March 2017 to 8,100 in June 2025. The alcohol tag, for example, having a 97% success rate. When the judiciary get more confident and understand how it works, then it will be used more and more. As we roll out more GPS tagging and all the other ideas we've got around, I think it will keep building on that. But when I was having a conversation when we were preparing for the committee today, and I thought maybe if Jim could fill in some of the gaps on that, because he knows more of the background to me on the court side of things, if that's okay.
So just a few bits to add, if I may. So the Minister referenced transforming rehabilitation. I think it's right to say that since those reforms, there has been a decline in the use of community sentences more generally, and not to the scale that we've seen around EM requirements specifically, but I think those two things link to the aspect that is a kind of indication the courts don't have confidence in EM. I suppose I'd point to the counter point of data that courts' use of EM on bail has grown significantly. So I think it's linked more to the after effects of TR, transforming rehabilitation, rather than courts' confidence in EM as a disposal type itself.
I could just interrupt though. The point I'm making is that our concern and the concern of the government is to see EM as an alternative to prison for those offenders who are suitable, who are at the moment going to prison in droves. So unless the courts start to see it as an effective alternative to prison with a suitable level of punishment and effective implementation, they're not going to be using it as court sentences. It's great about the bail, but that's not really addressing that core issue. So my question is, does the government need to do a specific job in relation to the magistrates and the judges in relation to this? And I would also include the public in that, because I do think that the public don't see tagging always as an effective punishment and a rigorous outcome for an offender. I don't know if you'd agree with that, but what is the government planning to do about this attitude amongst the magistrates and the judges?
If I could pick this one up, I'm going to answer it in two ways. One is, come back to the point on we need to run a really good service that's accurate, and that's what gives people in the judiciary reassurance. They need to see that when someone has been sent on tag away from the court, that they are tagged and they comply. Also, from a victim's point of view, it is really important that they are reassured that someone who is on a tag doesn't come into their life in the way that they don't want them to. And that is why the restriction zones that we are proposing in the bill are really important, and I think will go a long way to reassure victims, often of domestic abuse, that they can be safe to go about their lives, and there's only a small area where the perpetrator goes. So I agree that when a service is not operating effectively, people question that service. That's why we need to make it operate far more effectively. But it is important that by the time we have the next election, there'll be more people in prison than ever before, and more people on probation than ever before, and more people on electronic monitoring than ever before. So as we grow those three areas, it's important that not just the judiciary, but victims especially, are reassured. The technology is really robust, but what we need to do is to make sure the accuracy improves, and we want people to be more compliant who are on their electronic monitoring. And we know, for example, that the alcohol tag is really effective. We just need to keep building on that. So, the more alcohol tags we have out there in use, the better it'll help people address their addiction issues. So I think we just need to keep working really hard at it.
And I would argue, in terms of the list of things that you said need to get better, that victims, particularly and the public, can depend on the human intervention that would be necessary from a failure of compliance of one sort or another actually does happen. I've had several instances in previous lives where that doesn't happen. A victim of domestic violence, man subject to restraining order, informed the police, nothing happened. So it's the human intervention, isn't it? It's the probation service and the police as well, that they intervene when the compliance doesn't happen.
I completely agree. And there are two areas that I think are positive going forward. One is the significant increase we've got in probation funding, and the other is the investment we've got in systems and tech, because so much of the probation system is clunky. And for example, when I went to the Serco Centre, they're dealing with emails from probation officers, from courts, but we need to have a much more integrated system. So we've got a number of trials, a number of initiatives that are happening that are meaning that there's far more time for probation officers to do that face-to-face time with offenders, which is absolutely vital. Rather than hunting for various bits of information, I want their time focused on face-to-face with offenders, helping them turn their lives around.
Just need to follow up with something a bit different, if that's okay. Have you looked at how far and whether it's sufficient the compatibility of electronic monitoring in its various forms with human rights obligations?
It is fully compliant with the Equalities Act. Yep.
Thank you.
Could I just pick up that perhaps Baroness Hughes was too polite to push you on. She asked you on a number of occasions, did you agree that the public and the court needed to have greater confidence in the efficacy of electronic monitoring? To which you replied yes, and you talked about some jolly good bits of evidence that showed that things were working. But the truth is that the public are not aware of all of this. So her question was also, what are you going to do to actually educate both magistrates, courts and the public about the success and the benefits of electronic monitoring, other than just making sure it works well?
Some of our work on communications is important here. So last week I spoke to a couple of journalists who did a trial on some of our parts of EM to show how the 20% reduction in reoffending works, for example. So we're trying, we're doing the communication side of things, but I know there are television companies out there that I don't think any producer would go along to a broadcaster and be able to sell a story that says how well EM's going, but I just come back to the point is, from my experience of running organisations, the way you get good feedback from the public is by consistently delivering a good service over many years.
I'm sure that's true, but it does need to be promoted. And of course, it's not been helped by the very negative publicity that came out from the dispatches programme in the spring earlier this year. So it does strike a number of us that much more does need to be done on the communication strategy in the same way that we argued as a committee needed to be done about the benefits to public safety of reducing reoffending in prisons. And the same argument applies to this.
I'll hand over to Jim to give us more information.
So just a couple of points to go to your observation, Lord Chairman. So we've got a programme of work sponsored by the Senior Judiciary of engagement with judges and magistrates across the country to try and achieve the point you've raised around raising both knowledge and confidence in the service. I don't have the recent data to hand, but I think it's true to say that there is quite significant disparity in the use of EM and different types of EM between individual courts. That, I think, evidences the point you're making, that there is a job of work for us to do to ensure that judges, magistrates all feel both cited and then confident in the EM services that are available to them. In terms of the wider public, I think we've had a perpetual challenge around raising public awareness and confidence in community-side justice more generally. I remember when I first started working in criminal justice 20 years ago, an Ipsos Mori poll that I think pointed to 90% of the public believe they know what the police do, had confidence in the police. Something like 20-25% would say yes to both of those questions for probation and youth offending teams. And there's a bit of a mystery, I think, for many of the public around what we do with offenders. I'm sure there'll be concerted effort from the department over the course of the next months and years as the sentencing bill makes its way through Parliament to look to try and address some of that gap.
Can I just add in one other point, Chair?
Please do.
Intensive supervision courts, which we've got 4 at the moment, are an interesting example of this, of giving confidence to the judiciary, not just on EM, but how probation links in with drug and alcohol teams, mental health teams, housing teams, and so on. And if you take the one in Birmingham, which is a female offender intensive supervision court, where often alcohol tags can be given as part of the arrangement with the offender, and they go back every week and prove that they haven't been taking alcohol, but also they've been engaging with all the other services. The longer that goes on, the judiciary become more and more confident in the services that they work with. And I've seen that in Liverpool and in Bristol too.
That's very encouraging, but I think Mr. Barton's point, quote, "there's still work for us to do,"
very much so.
Is something we'll take away. Baroness Burton.
Can I just start with following on from the dispatches programme and the sort of negative media coverage? And I do absolutely accept that the media are not going to go out and do sort of positive coverage, but I still think it's very important not to dismiss what that programme uncovered. I mean, some really, really sort of worrying comments from the whistleblower, saying the system was in chaos, saying also that one of the more worrying things, quite aside from somebody's going to get hurt, trying to tag people who've deceased, all these sort of list of things, but saying that a line manager had told them we can recognise that it's a system error, but that people that create the system aren't willing to accept that it's a system error and that someone's going to get hurt. I mean, do you recognise any of that? And the fact that they are being fined for poor performance every month since the contract was awarded?
I completely agree. The programme was shocking. The delivery of the service is not acceptable. Financial penalties have been applied, as you say, and that's why I've been on this and directly intervening. I mean, I don't think really we should be in a position where a minister should be worrying about a contract every week in their job amongst all the other things that are going on. But I've had to have been, and we're in a much better position now. But when that programme was filmed, the service that we were receiving was unacceptable.
And just to come in on that, but isn't it kind of extraordinary, it's jaw-dropping, that here we have a company, Serco and Allied Universal, formerly G4S, having defrauded the government to the tune of £21.3 million. I agree, I accept it was before your time, and yet they were still allowed to get that contract. It must stick in the craw.
Well, that was before my time, so I'll hand over to Jim on how the contracts were done. But I'm dealing with what's in front of me. I inherited this contract. I inherited all the problems with the contract, along with all the other problems in the justice system. And I'm in the business of dealing with it and facing up to it. And you do that by robust challenge, communication, and just grinding it out. And that's what we've done. We're not in a position where everything's perfect and everything's green at the moment, the way I describe it. But we've come a long way. But we needed that challenge. It was unacceptable. But just going back to your question on the companies themselves, Jim, would you come in on that one?
Sure. If I may just make one point in reference to your previous question, if that's okay. So just on the reference in the dispatches programme to Serco in some way trying to tag or claim that they were tagging deceased people, wholly reject that allegation. Serco did as well. From my perspective, that is a spurious allegation with absolutely no evidence to back it up whatsoever. On the point around the current contracts and the process we went through, so you're absolutely right to refer back to the fact that both Serco and G4S, a precursor organisation to Allied Universal, were subject to investigation by the Serious Fraud Office. As a result of that, they both paid back money to the ministry and then paid fines to the ministry for the actions that they'd taken. Both companies were subject to deferred prosecution agreements with the Serious Fraud Office. Both of those processes have essentially concluded. When we were beginning the process for the reprocurement that has led to these current contracts, we of course stood back and considered exactly how we wanted to kind of position those contracts with the market, back to some of the conversation we were having before about how we divided it up, but also how we would structure that evaluation. We had absolutely no lawful means to take a decision that Serco or G4S, Allied Universal, should be disbarred from that competitive process.
Well, even though they'd had a deferred prosecution agreement?
Yes. So under the previous procurement regulations, we had no lawful means to disbar them from that competition. There has since been a change to the procurement regulations that came into effect this year that tightens that extends some of the options available to the authorities who are procuring services to consider past performance. Those procurement regulations were not in place, they did not exist when we went through this competitive process. I think it's right to say it's still to be tested exactly how those new powers will operate when an organisation chooses to apply them for the first time.
Well, that just strikes me as extraordinary, but I accept what you're saying. But I think it just leads, the final point I want to make and put to you is, are we not really in a situation, particularly on the monitoring point, because I accept that the suppliers of the tags, there is more competition, but really on the monitoring side of things, there's not much competition at all, so you can't really let Serco fail.
So it is factually accurate that we have one provider of field and monitoring services in England and Wales. We have, as you referenced, taken every single contractual lever and penalty that we can over the course of the last year as an incentive for Serco to improve performance. That's in addition to all of the scrutiny and challenge that the Minister has directly provided to Serco seniors. As the Minister said, performance has improved significantly. I don't think we're in any world at the moment where we need to give consideration to wanting to take that contract off Serco or Allied. Of course, we would always plan for contingencies, but we're not in that world.
But I don't know where you take it anyway. But anyway, I rest my stop there.
Well, can I just take it on a bit further? It does seem extraordinary from the answers you've given as to what's happening with these contracts. And I just want to know how the MOJ is going to ensure they are getting best value of money for the taxpayer in these contracts, because they need proper monitoring.
This is where my business head comes in. And I don't like wasting money, and I want to be part of an organisation that is excellent. And the way we get good value for money is Serco and Allied delivering on everything they need to deliver, and we need to deliver as well on our side of it. It's a combination of us all working together, and that's how we get good value for money. Where they go against a contract, we have financial penalties, which we've been putting forward
and again.
Yeah, but in my weekly electronic monitoring update meetings and my dashboards that I get, things are very much going in the right direction. As I said earlier on, it's not on my worry list now, but I'm still monitoring it every week. We want to get to a position where all the indices are in green. It's like any organisation want everything to be in the right place. We're not there yet, but we're very much on the way. And if you look at what it was like 14 months ago, what I inherited, it's a different world.
Sorry, just in our report on prisons, we actually suggested that it would be a very good thing for the minister doing your role to stay in post for a very long period of time. And clearly, in relation to electronic monitoring, we no doubt would come to the same view. But the truth is the system cannot rely on you and you alone. So the fact that you have taken a greater interest in monitoring, and clearly there have been some improvements, is clearly good news. But surely the department must have changed the way in which it is now doing contract monitoring, because quite clearly it was failing miserably in the past, as the evidence that my colleagues have already illustrated shows. So what changes have been made to the contract monitoring procedures within the department?
First, I can't comment on what happened by the previous government, but I can reassure you that the colleagues I work with, not just saying this because Jim is here and some of the team are here, are first-class public servants. What I have brought into this is my experience in business of making sure that things are monitored every week, and so I've simplified. What I asked for is the sort of the headline numbers and a very much simplified version. But also, I've given the team the support as minister, which I don't think they probably got in the past.
I'm enormously grateful for that, but sorry, I will press you a little bit harder. If you drop under the proverbial bus, which obviously we hope doesn't happen, or if the Prime Minister shuffles you off to some other job, are you confident now that the procedures, not the personnel who you have faith in, but the procedures within the department are now sufficient that the monitoring of this contract, which is growing enormously in value with the doubling of the number of people who are going to be tagged, you're confident that that monitoring procedure will be first class?
Well, maybe I could answer in two ways and bring Jim in for the second part. The dashboard and monitoring systems that I have set up will endure, and it's pretty clear with our Serco partners, allied partners and so on, everyone sees the data all the time. We have MOJ staff who are based in the Serco Warrington call centre and their teams as well. It is very much an interlinked one. But maybe Jim could tell us, what, in your view, Jim, what has changed and whether the robustness of the system has changed?
Sure. So two thoughts. So the first is something that is materially different under these contracts is that we have direct access to Serco systems. So previously we would rely on their ability to provide information to us on request. I have a team that sits in Warrington with Serco who can go into every aspect of the case management systems that are used to monitor the 24,000 people out there with a tag on their leg. That's materially different. It is that right of access that has helped us on occasion be the ones that have shone the spotlight on problems as they have started to emerge with Serco. Lord Chairman, you frame the question in exactly this way, but I would push back if the inference was that this is a failure of contract management, because I genuinely don't believe it is. Serco took on a service that had some challenges on the 1st of May. Over the course of 6 to 8 weeks, those challenges built at pace. We were on it straight away, but it took time for Serco with us to come up with the right set of interventions to tackle those issues. So, of course, there are always things we can do to improve contract management, but I don't believe that the fact that led to ultimately the dispatches programme paints a picture that shows or evidences failures of contract management.
And just to complete the picture, if we can, in terms of the contract specification, right at the beginning, are you confident that the staff within your team have got the ability to draft appropriate contracts as we go forward and extend the use? Was any of the issues that were discovered and reported, for instance, in dispatches programme that you yourself picked up anyway, Was anything that down to the inadequacy of the contract that was drafted at the beginning?
I don't believe so, but of course, contracts are vast and complicated, and I'm sure if we put forensic lawyers in a room, they'd find aspects of the drafting that they would improve. What I would point to, and I think Anthony King from Serco perhaps referenced this in his evidence, is that we with Serco have been undertaking an incredibly complex IT and operational migration. So we're moving off a system that is 20 years old onto new best-in-class systems. There have been issues that we and Serco have found through that process that were not foreseen. But I think I would speculate that you could put any SRO of a major programme in this seat, ask them the same question, and they would have to accept the same, that there are some things you just do not foresee at the outset. The important bit is how quickly you identify them and how quickly you then respond and mitigate the impact.
Okay, well, if we can now just turn to pick up two of the issues that might have been written differently within the contract, and we'll go with Lord Timpson.
Yes, is it appropriate, I know that is the state of things now, but is it appropriate that the contracts should be run by, should be commercial, run by companies, or should it belong more properly with the, with probation, immigration, police, etc.?
EM has always been run under private contracts.
So they really mean that's the right way to do it?
And my view is that I'm dealing with a contract that we've got now. It's got a long time to go, but it is a partnership of police, probation, Serco, Allied, and all the other agencies that feed in. I am content that we are going in the right direction with the contract. The Lord Chair mentions about the proverbial bus that may take me out, but I prefer to use the Euro Millions option as the other way out, rather than the bus. But we've got a long time to go on this contract, and I just want to get it to a position where it's working really effectively, and we're really proud of what we've achieved.
Go on. No. Another area of the contract, Lord Timpson.
Yes, thank you. Thank you, Minister. You've already mentioned, I think you used the phrase tagging at source, and I'm interested to pursue what happens in terms of tagging to prisoners when they leave prison. You've got some experiments going on in 6 areas, 6 prisons, I believe. Could you say a little bit more about that? And how long will they be tagged for? And will all prisoners be tagged, or just some, depending upon what they were inside for?
It is our vision that most people leaving prison will be tagged as part of the sentencing review and the way the progression model works. Not all, but most. And the trial we're doing at the moment, I'll ask Jim to give you the details of it, but it's to improve accuracy, because some people leave prison and when Serco go to their house to tag them, they're not there, or there are other reasons why the tagging has been unsuccessful on the first or the second go. So it's about improving accuracy, but also helping prisoners' rehabilitation, because if we can get an alcohol tag on them when they're in prison, they're far less likely to go to the pub on the way home to get their first tag on. So I do think tagging at source is important. We need to do the trial to see how it goes, but it is an important. Maybe if I could hand over to Jim, because there's some technicalities around it.
So a few bits to add, if I may. So the plan, you're absolutely right, is to test this in 6 prisons starting next month in October, with the aim that we would then evaluate how this has worked from a kind of an efficiency and an impact perspective, so that we can take a decision next spring as to whether this is something we want to do at greater scale. The Minister referenced previously, we'll also be thinking about, should we be running an equivalent pilot in some courts during that period of time? We're just a little bit less advanced on that. Perhaps just to explain why we haven't historically tagged at source and instead operate the default model of going to somebody's home, it's principally to do with the way that the radio frequency curfew bit of the technology operates. So we can fit a tag on somebody's leg at prison, and that will have GPS within it, so we'll be able to kind of know where that individual has gone post-prison. But for the curfew bit of the EM requirement to work, it requires the radio frequency bit of the tag to talk to what we call a home monitoring unit. So it's essentially a base station. It looks like a kind of skybox or a PlayStation, depending upon your point of reference. And the member circle staff will go into that flat or the house, and they will calibrate the radio frequency device. They'll get the individual to walk around the premise so that it's incredibly accurate to the perimeter of that lodging. If we were just to rely on GPS, so not have that calibrated home monitoring unit, it's less accurate. So to give you an example, if this were a block of flats, it's clearly not a block of flats, but if this were a block of flats and this was your apartment, then with GPS, we would know you were in the block of flats, but we probably couldn't pin you down to were you in your abode and had you left it overnight. So it's likely, therefore, that with tag at source, we'll need 2 visits, install the GPS tag on release, and then follow up when they're back home to fit the home monitoring unit. And it's just the interaction between those 2 things that we want to test through the pilots.
And is it that this new, fairly new technology has stopped you doing it a long time ago? Otherwise, my question would be, why haven't you done this years ago?
We piloted GPS in England and Wales back in 2018 and then started to roll it out at scale in 2020, I think. And we did try this previously during COVID. So you may all remember there was a scheme called ECSL, I think, so many schemes, so many acronyms, that was in response to a concern that we may have needed at that point to release a number of prisoners to manage the COVID risk within prisons. Ultimately, a very small number of people came out under that scheme, but they were tagged at source. Our reflection at the time was there was an inefficiency in it because we had to do those 2 visits. But the use of GPS has just grown so much. Back in 2020, 21 under COVID, it was a very small number of cases that had GPS. It is now the majority mode of tagging. So we think the use case for it or the reasons to explore it again are just very strong. So we agree with the principle of your observation that this seems like a sensible thing to do. We want to try it, do that in a safe way, make sure we can explore with prison staff and others, is this working for them, and then take a decision next spring about whether we roll it out.
Thank you.
Lord Barton. We really end where we began, I think, which is around the question as to whether the public can support and will support non-custodial sentences in the same way as they sometimes support custodial sentences. So the question really is, in reality, is it too easy to game the system with electronic monitoring? And do people really feel the consequences of a serious breach of the system? Taking the Minister's comments about the person who said they went to the doctor, but in fact were found to have been enjoying Blackpool. Are there all sorts of examples of where that happens, or more serious examples, where people really are, in the Ministry's opinion, dealt with in a way that will satisfy the public, who are anyway a bit wary and sceptical about non-custodial sentences? And I speak as someone who's very much in favour of the way in which things are moving forward now, not before time. But there is still that question of persuading the public that this way of dealing with criminals is satisfactory. What's both your opinions on that?
Well, when you talk about the public, I'd also like to add in victims specifically.
Of course.
I'm really clear that if people break the rules, we've got the option to recall them back to prison. And the police, if someone is bailed, have the option to bring them back to court if necessary. So to me, it's pretty black and white, which is we put a tag on you, the rules are pretty clear. If you break the rules, the probation team or the police have a duty to assess the degree of that breach. But our ultimate option is recall back to prison. And the victims especially need to feel the comfort in that, especially those who are being stalked or victims of domestic abuse. the courts have given someone a tag. They may have been to prison and left on a tag, or have been given a community sentence. And if they break that, the victim needs the comfort to know that they have the option to send them back to prison.
If I could just come back on the first point around the extent to which you can game the system. Yes. So all of the tags have quite complicated technology embedded in them that prevent tamper, essentially. So if an individual looks to interfere with those tags, including kind of inserting something between the alcohol monitoring sensor and their skin, then that will trigger a notification that then gets sent through to Serco, who will notify the responsible officer. In some ways, our challenge is too much noise in the system. So we perhaps back to Lord Dubb's challenge from before, we have a really robust approach to electronic monitoring. So taking the example of this being an apartment again, if you walk out that door and have a cigarette or go for a walk with your dog, we will know that. Now, is that grounds to take somebody back to prison? Probably not. I think certainly not in 99.9% of circumstances, but that's still information that we rightly want to consider and to use in the way that we manage that offender or the police manage that court bail instance.
Thank you very much. Baroness Hughes.
Thank you. I'm sorry, Mr. Barton. I want to just return briefly to the question of contract monitoring. And I'm sorry I couldn't do so at the time. I was looking for information that actually came with papers for a previous meeting. I couldn't put my hand on it initially. And it really relates to the competency of HMPPS in the contract managing role. Because we were informed that in relation to Serco specifically, not Allied, but Serco specifically, overcharged the UK government by £500,000 a month for over 2 years and were found guilty of fraud and false accounting. And as a result, we know they were fined and so on. How can it be that a team of officials, civil servants, could fail to ask questions about that degree of false accounting and dishonesty over such a period of time? I really, it beggars belief that you could say it was not in any way related to a failure of contract management oversight.
With respect, so obviously, from my point of view, I can't answer that one. But just say, as someone who's paid a lot of tax in their life, I take my responsibility very seriously to making sure that every penny that we spend is not wasted. And that's why contracts need to be properly procured, but also they need to be held account. They've got to deliver on what we're paying for. It's really important.
I agree.
And could I just hand over to Jim on the detail of the...
The evidence here is that left to their own devices, officials did not provide the level of contract management surveillance that was required. £500,000 a month?
Just to clarify my earlier evidence, because I did not say that those events back in 2010 and 12 were perfect contract management. My response to Lord Chair was specifically about this contract and this period of time. I was not directly involved in the oversight of the EM contracts back then. It was ultimately officials who identified that failure and recouped that money for the public purse. One of the issues at the time was about lack of access to Serco and G4S's internal data that allowed for the verification of the bills that were landing with us. We have corrected that under these contracts because we have full and open access to their systems. So I'm not for a second suggesting that experience was the civil service's finest hour, or that there weren't failures in the way that we managed those contracts. There was an internal review following that experience by one of the MOJ non-exec directors at the time. He recommended that we significantly increase the proportion of contract value that we spend on contract management teams. That is something that we have done, and it's a benchmark that we continue to use to this day. So apologies if my earlier evidence was misspoken or misheard. I was not suggesting that 2010 to 12 was our finest hour. Final reflection just on the theme around the market dynamics here. It's obviously right that we now have one organisation delivering field and monitoring, one doing the tags, but both of those competitions were highly competitive. So we had multiple bidders in both of those competitions. Serco and Allied won it because they advanced the best bids based upon the evaluation criteria that we set out. Thank you.
Our time is coming to an end, but just before we finish, Lord Filkin wants to jump in, and then there's one final question. Lord Filkin.
Thank you very much, Chair. If I heard the Minister correctly, he stated a policy ambition that most prisoners will be tagged on release. I may have missed it, but I've never heard that stated before as a government ambition, and it is quite remarkable. Could we be, I doubt if there's time now, but could it be written to explain who would be and who wouldn't be in your broad thinking, what the numbers would be implied by that, and your analysis of what the benefits would be of that. Is it workable and is it beneficial? Because it is a quite remarkable, and of course it begs the question, and for how long would they be tagged? It isn't presumably for life. So I have some very important questions, both about public policy, policy delivery, civil liberties, and above all, ability to reduce reoffending by doing such actions. Thank you.
Of course, I will write, but maybe if I could just highlight two things. One is we're predicting an increase in the number of people wearing electronic tags by 22,000. And I'm sure when the sentencing bill comes into the Lords, it'll be an opportunity for us to inquire further about that. But I will write to the committee, trying to give you as much detail as possible on those questions around tagging when people leave prison.
Can I just, to close it, it is your, I heard you correctly, it is your ambition that most people will be tagged. So let's have the numbers on that, on what then would happen to the systems with that volume coming into it.
Yes, of course.
Thank you. And as you say, as we study the sentencing bill, that will provide further opportunity for debate. Could I just end by asking you the sort of slightly fun question, but to both of you, if you could wave magic wand and get rid of various sort of financial constraints or legislative constraints, is there anything in the area of electronic monitoring that you're actually keen to do which currently you're not able to do?
I mean, I've been through the new ideas that we're looking at. Beyond that, at the moment, I don't think there's anything else. If I was going to sort of look into the future, sort of 10 years in 10 years' time, the way technology is going and the way AI is going, I do envisage a time where the people have a tag or a watch that is anti-tamper, that is a device that also helps more with rehabilitation. It can check whether they're taking drugs. It can be more of a support to them, a medical support. It could be ways they can learn things. Because there are a number of people who leave prison that aren't sophisticated to understand how technology works. So it needs to be a way that they can understand how it can help them. Because what I'm after is fewer victims.
I'm hoping our finance director is watching this. I'm hoping our finance director is watching this evidence session right now. So I think personally, I think I would push for is for us to roll out and expand the acquisitive crime work that the Minister has spoken about. So we're currently in half the police forces. It's fair to say National Police Chiefs Council would be keen that we roll that out. I think that then enables a conversation about, and should we think about expanding the crime types that are in scope for that pilot, and then really lean into the work the Minister's already referenced that we are doing around making best use of the data that is then available, so make that data available quicker and in a more targeted way, certainly for probation, and then smooth the point of access for police forces to the same.
I'm sure that if you haven't already, an engagement with Lord Hogan Howe about these matters would come high on your agenda, since he's very enthusiastic about that.
I'm in regular conversations with Lord Hogan Howe, and we're arranging, we're giving him an insight into how the service works, because I know he's interested also from a police point of view as well.
Can I just ask one final question? Because as we expand all of this, there are growing concerns around the areas of civil liberties. And I just wonder if you can reflect any thoughts you have on the issue of civil liberties as we get into an increasingly surveillance society.
Just my point of view on this is that victims come first, and the courts will decide what sentence people get. But if they leave prison and they're on a tag and probation are monitoring them, I think that's the right way to go. And if people commit crime, then they need to pay the price for it.
Thank you. Barton, anything to add to that? No. Okay. Can I just say on behalf of the committee, as ever, it's been a very, very helpful session. We've learned a great deal. We'll be drafting some remarks about electronic monitoring over the next 3 or 4 weeks, and we'll get them to you. There's a number of areas where you've already agreed to write to us, and we'll look forward to receiving that. And of course, if there's anything further that you haven't had the opportunity to say that you think would be helpful to us, we'd be really grateful for that. But with that, can I thank you both and your team, who I know are with you as well, for the work that you do and for the evidence that you've given us today. Thank you very much indeed. Order, the meeting.